John Marshall was an American politician and lawyer who served as the fourth Chief Justice of the United States from 1801 until his death in 1835. Widely considered the most influential jurist in U.S. history, Marshall laid the foundations for the Supreme Court's role as the ultimate interpreter of the Constitution and paved the way for the expansion of the federal government. Born September 24, 1755, Germantown, Virginia, United States. Died July 6, 1835, Philadelphia, Pennsylvania, United States. It is emphatically the province and duty of the judicial department to say what the law is. If two laws conflict with each other, the courts must decide on the operation of each. This is of the very essence of judicial duty. The most lively fancy aided by the strongest description cannot equal the reality of the opera. When a law is in its nature a contract, when absolute rights have vested under that contract, a repeal of the law cannot divest those rights. The power to tax involves the power to destroy. The power to destroy may defeat and render useless the power to create. To obtain a just compromise, concession must not only mutual, it must be equal also. There can be no hope that either will yield more than it gets in return. The institution of Masonry ought to be abandoned as one capable of much evil, and incapable of producing any good which might not be effected by safe and open means. My gift of John Marshall to the people of the United States was the proudest act of my life. There is no act of my life on which I reflect with more pleasure. I have given to my country a judge equal to a Holt, or Mansfield. It is the peculiar province of the legislature to prescribe general rules for the government of society. The application of those rules to individuals in society would seem to be the duty of other departments. I have always believed that national character depends more on the female part of society than is generally imagined. Precepts from the lips of a beloved mother sink deep in the heart, and make an impression that is seldom entirely effaced. Have no power, by taxation or otherwise, to retard, impede, burden or in any manner control the operations of the constitutional laws enacted by Congress. The French Revolution will be found to have had great influence on the strength of parties, and on the subsequent political transactions of the United States. Seldom has a battle, in which greater numbers were not engaged, been so important in its consequences as that of Cowpens. The power to tax involves the power to destroy. The Constitution is colorblind, and neither knows nor tolerates classes among citizens. The law does not expect a man to be prepared to defend every act of his life which may be suddenly and without notice alleged against him. An unlimited power to tax involves, necessarily, a power to destroy, because there is a limit beyond which no institution and no property can bear taxation. The people made the Constitution, and the people can unmake it. It is the creature of their will, and lives only by their will. A Constitution, intended to endure for ages to come, and, consequently, to be adapted to the various crises of human affairs. It is emphatically the province and duty of the judicial department to say what the law is. To listen well is as powerful a means of communication and influence as to talk well. A legislative act contrary to the Constitution is not law. Between a balanced republic and a democracy, the difference is like that between order and chaos. It is emphatically the province and duty of the judicial department to say what the law is. No one imagines that a law professing to tax will be permitted to destroy. The people made the Constitution, and the people can unmake it. It is the creature of their own will, and lives only by their will. I fear we may live to see another revolution. A constitution is framed for ages to come, and is designed to approach immortality as nearly as human institutions can approach it. What are the maxims of democracy? A strict observance of justice and public faith, and a steady adherence to virtue. What is it that makes us trust our judges? Their independence in office and manner of appointment. The government of the Union, then, is, emphatically, and truly, a government of the people. In form and in substance it emanates from them. Its powers are granted by them and are to be exercised directly on them, and for their benefit. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. The peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. The government of the United States has been emphatically termed a government of laws, and not of men. It will certainly cease to deserve this high appellation, if the laws furnish no remedy for the violation of a vested legal right. No political dreamer was ever wild enough to think of breaking down the lines which separate the states and compounding the American people into one common mass. In a free government, almost all other rights would become worthless if the government possessed power over the private fortune of every citizen. The acme of judicial distinction means the ability to look a lawyer straight in the eyes for 2 hours and not hear a damned word he says. The law does not expect a man to be prepared to defend every act of his life which may be suddenly and without notice alleged against him. The federal government is acknowledged by all to be one of enumerated powers. The principle, that it can exercise only the powers granted to it, is now universally admitted.